My name is Amelia Yomalakis, and these are my co-counsel.
Hello, Your Honor. My name is Henry Morris.
Hello, Your Honor. My name is Elena Mosby.
Together, we represent the plaintiff in today's case, Ms. Elizabeth Ginger.
Hello, Your Honor.
Good afternoon.
Your Honor, may I approach with a couple of documents for your reference throughout today's trial? Defense counsel has already seen these. It's a copy of the complaint, the stipulations, as well as the available case law, Your Honor.
Maybe we make introductions as well.
Yes.
Good afternoon. My name is T.C. Sample, and I'll be delivering the defense's opening statement. To my right is Ms. Jaleesa Harris.
Good afternoon, Your Honor.
To my left is Ms. Maisha Ishmael.
Good afternoon, Your Honor.
She'll be delivering the defense's closing statement. Today we represent the defendant, Mayor Max Heisman.
Good afternoon, Your Honor.
Good afternoon, sir. I understand that we have some pre-trial matters.
Yes, Your Honor. There are two things that we would like to bring the court's attention to. First, Stipulation 4. This is a case of election fraud taking place in Truman Midlands. Truman Midlands has 12 voting districts. We are not alleging that fraud took place in the 1st through the 11th district, but that election fraud did take place in District 12.
So your request for stipulation would be
Just to take judicial notice, Your Honor.
any objection?
No, Your Honor.
Court will accept the stipulation that the issue before the court relates specifically to District 12 only. Any other pre-trial matters?
Yes, Your Honor. If you'll take a look at the available case law, the second case law on that first page, it's Ojeda v. Fly. Now, in a case of election fraud, if the plaintiff can show that the defendant committed election fraud, we do not have to put forth separate evidence that that fraud changed the outcome of the election. A rebuttable presumption is created if the plaintiff can show by a preponderance of the evidence that the defendant committed election fraud either alone or in conspiracy with others.
And you're asking me to
Just take judicial notice, Your Honor.
for purposes of the trial.
Yes.
Any objection?
Yes, Your Honor. The opposing counsel is misquoting the case law. This case law states that if the opposing counsel can prove that the defendant intentionally committed election fraud, then there would be a presumed assumption involved in this case.
So your argument is that they have to establish that the fraud was intentional prior to the presumption?
Yes, Your Honor. The case law states that if opposing counsel throughout today's trial establishes the fact that Mayor Heisman intentionally committed election fraud, then the jury would presume that the outcome of the election would have changed.
Any response to that?
That is our understanding of the way that the charges and the evidence will work today, Your Honor. That an intentional election fraud has to be shown. That Mayor Heisman intentionally acted alone or in a conspiracy with others to mislead the voters in District 12.
So it sounds like both sides are in agreement that that is what the standard of proof must be.
Yes, Your Honor. We just wanted clarity for the record that they have to prove intent according to this case law if they choose this case theory in today's trial.
Thank you.
With that, Your Honor, plaintiff is ready for opening statements.
Anything from the defense by way of pre-trial motions or stipulations that you'd like to address before we begin with openings?
Yes, Your Honor. The defense has two documents to tend to the bench as well. This includes the answer to the plaintiff's complaint, as well as a copy of the Midlands Rules of Evidence. Opposing counsel has seen these documents. May I approach intended?
Yes. Plaintiff has copies.
Yes, Your Honor.
answer as well as the Midland Rules of Evidence. Anything additional from the defense?
Yes, Your Honor. Since this is the first time we're in your courtroom, may we have permission to move about the well freely?
Yes.
For the-
Permission granted. Please request permission to approach the witness prior to approaching.
Yes, Your Honor. Will we be required to ask permission before approaching opposing counsel or the bench?
No.
Your Honor, since we're in the state of the Midlands, it's presumed that all trials are jury trials, so we ask that it be noted that all statements and testimony be made to the jury.
Any objection?
No objections, Your Honor.
Granted.
Lastly, Your Honor, we move to invoke Rule 615. This is the constructive sequestration of all witnesses except for a party representative from each party. For the defense, that'll be Mayor Heisman.
Ms. Ginger will sit at council table today. She will not be taking the stand, though, Your Honor.
Sequestration in accordance with the rules is granted. The parties are required to inform their witnesses. Anything additional from the defense?
No, Your Honor. The defense is ready to proceed into today's trial.
Okay.
Yes, Your Honor.